Good morning. My name is Jeff Cleaver, and I'm the Executive Director of the Business Healthcare Group. And I'd like to welcome all of you to our Delivering Value Series Symposium this morning. Jolene, can you go back, please? On hot topics in benefits law, Roe versus Wade overturned, and implications for employers. And I know all of you are incredibly busy, especially at this time of year. And once again, I'd like to thank you for taking time out of your day to join us. Next slide, Jolene, please. If during the course of the webinar this morning, you have any questions, just enter them into the Q&A section on your screen. And John Barlament will answer your questions at the end of his presentation. Next slide, Jolene. So today's presenter is John Barlament. The Business Healthcare Group and myself have worked with John for actually a very long time. And we have an incredible amount of respect for the value that John brings, not only to the Business Healthcare Group, but also to our member employers. And many of our member employers utilize John's services through Reinhardt. So John is an attorney and shareholder with Reinhardt, and he's a member of the firm's employee benefits practice with a focus on health and welfare plan matters. John is a frequent noted national speaker and author on employee benefits topics. He's been included in the Best Lawyers in America from 2010 to present, Employee Benefits and ERISA Law. And you can see John's contact information at the bottom of this slide. So with that, once again, I'd like to thank John for not only joining us this morning, but also taking an incredible amount of time to put together the presentation this morning. And you will hear about at the end of John's presentation about an opportunity to purchase a chart that I think you will find incredibly informative, and it will provide information that you will be able to utilize in working through many of the issues associated with Roe versus Wade. So with that, and John is going to speak to what he has developed within the chart also. And so with that, John.
Excellent. Thanks, Jeff, and thanks everyone for being here today. Wanted to dive into this topic in terms of the operational issues you should be thinking about in terms of Roe versus Wade being overturned, really with a focus on employers and plan sponsors. I know we have some advisors, some benefit consultants, things like that on the line today too. I do think that this will be helpful because you're probably getting questions from your employer clients about these issues also. So again, we'll kind of walk you through what the different considerations are that we see out there. Why are we here? As many of you know, I'm sure, Roe versus Wade from about 50 years ago and some later Supreme Court cases, like a case called Casey, provided minimum guarantees for pregnant women to obtain abortions. States could include some restrictions on abortions, but the rules varied by the length of the pregnancy. Basically kind of a trimester sort of approach in Roe versus Wade. And then Casey kind of changed it to sort of a burden approach. Is it an undue burden? Things like that. So net takeaway is that there were some restrictions on abortions, which states could enact. Some states did, others did not. Others just said, nope, you can have an abortion at week 39. You don't have to even worry about it. So really a varied approach. Where did that leave employers, third-party administrators, pharmacy benefit managers? I mean, their health plans could essentially ignore, or at least as a practical matter, did ignore most state laws, which imposed restrictive obligations. So if a state said, no, 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 we're not going to allow abortions at all, except in the case of the life of the mother, if there's some risk to the life of the mother, most of the time, health plans did not, as a practical matter, really focus on those. There was a Roe preemption argument, there's an ERISA preemption argument. And so plan sponsors, I think, never really had to delve into this thicket of legal issues before. Now I think we're in a whole new world. I think that we've had it kind of easy for the past 50 years. And I think now it's going to be a world of perhaps state by state compliance if you go beyond what the Pregnancy Discrimination Act requires. And we'll talk about the PDA. I think there is a path where if you wanted to be pretty restrictive in terms of the abortion coverage that you provide, I think you would have at least an argument that the PDA may preempt some of these laws, but that is not completely clear. Very limited case law out there on that. But again, we'll kind of talk about that particular issue. So how did we get here? A couple months ago in Dobbs versus Jackson Women's Health Organization, the Supreme Court overruled Roe and Casey. They held that there's no right under the U.S. Constitution to any abortions at any time. So there could be total bans that a state could have, 6-week bans, 15-week bans. A lot is possible. The states can kind of go back to the drawing board and can, do what they want to do here. And unfortunately, from a compliance perspective, some state laws are very old. So Wisconsin has a very old abortion law from 1849. Texas has one from 1925. Many of these predate health plans in general, and certainly predate ERISA. And that has been complicated when I have looked at some of these laws, and I've looked at, I don't know. As we'll talk about in that chart, which is like 97 pages long. In the connection with that, I went through literally thousands of specific provisions of state laws that mentioned abortion. So literally thousands of laws which are out there. And then to try to apply those old laws to health plans, which really many of them didn't even exist when some of these laws were enacted. It's a difficult analysis. Health plans, in case you're not familiar with it, generally did not take off until World War II, when there were some price restrictions in terms of what companies could pay employees, and companies were trying to compete for employees. So they started offering health plans as an additional benefit. So the World War II era is kind of when health plans took off. And again, we're dealing with a 1925 Texas law and trying to apply it here in 2022. It's not easy. Some of these state laws impose civil penalties, some impose criminal penalties. You may have read about a recent Texas law, which is basically a $10,000 bounty law, which can be enforced by private individuals, where if somebody becomes aware that you had an illegal abortion, they can bring a claim against you if you aided and assisted in it. For example, if you were a taxi driver and you drove somebody to a abortion clinic, the taxi driver could have liability. There's also, of course, an argument that employers could have that kind of liability if you are the ones who are helping to steer members, plan enrollees to an abortion clinic, and if that is unlawful, again, you're going to have some potential exposure there on the civil side, unfortunately. Other state laws impose criminal penalties, and criminal penalties to me are worse. Obviously, we should care about both, right? We don't want to violate any law anywhere, but criminal is of greater concern. Just as a practical matter, I mean, when you think back to some of the companies which have faced criminal penalties, I think back to Arthur Andersen and Enron and some of these really, really big companies. What caused them to collapse? A lot of times it was criminal penalties, which can cause significant corporate problems. So to me, this is an issue that I think every company out there should be giving some thought to. I think it's a very significant issue, even if the risk of enforcement may be fairly low at this point. I do think it's a good idea that you're listening, and that you kind of work through some of these issues we'll be talking about here today. Other possible consequences Reputational harm, loss of business. We're starting to see that already where some companies have come out very strongly and said, we're going to provide travel benefits for abortion. And, I've heard about certain companies losing customers over that. And I've heard other companies where they've gotten praise for that. So, it's a tough one. It is kind of a politically charged and emotionally charged area, to be honest. So you won't hear me making too many abortion-related jokes here because this is a tougher area than usual, I'd say. So again, it is a tough area. Monetary damages again are also possible. Loss of license. We've talked to some clients about, can you just offload this to your TPA or PBM and have them handle everything? Sometimes the TPAs and PBMs are kind of pushing back and saying, hey, we don't want to have criminal exposure ourselves. We worry that in some states, even on the civil side, if we are assisting with something which may be unlawful at the state level, we could lose our license in that state. So it may be bigger than just one client, trying to keep one client happy. If you lose your license in a state, you could, cease to be able to operate in that state. And then some states have licensing laws that require you to notify them if you lose a license in a different state. It's kind of a domino effect. So in other words, if you get pushback from your TPA or PBM and they aren't willing to do a lot here to help you, it's probably because of that domino effect. They can see how they could lose their license in a number of states. So again, it's a tough one there too. In terms of the criminal risk exposure, we've gotten some clients who have asked questions about, can we just offload the risk by contract? The short answer is normally you cannot do that. You can't enter into a contract to have another person do a criminal activity on your behalf. That's generally against public policy. You can probably see why we don't, enforce as a matter of principle contracts for illegal services. So again, it's a tough one in terms of who within a company would be charged with a criminal claim. Again, hard to know. I think it could vary, but that's why it's got everybody's attention. Does it go to the board of directors? Does it go to the CEO? Is it more at the benefits director level? Again, hard to know what the possible exposure is. Right now, we have more questions than answers for some of these, unfortunately. In addition, we have been telling folks that you should keep in mind that all these state laws generally can be enforced by local prosecutors. So each county in a state may have their own local prosecutor. I talked to one of our white collar criminal defense folks, and they explained this to me. They said, for example, Texas has 254 counties. We believe that they may each have a local elected prosecutor, and each of those prosecutors could take their own interpretation of Texas law. And I can just see how some local elected prosecutor in some states will want to be the tough on abortion prosecutor who goes after out-of-state or foreign companies which aid or abet in providing abortions. And aid or abet is kind of a key term. We'll see that pop up in different states here. So we're going to have differing opinions on how to interpret some of these ancient laws. And we started thinking about the numbers here. Number of counties and local prosecutors, you quickly come up with prosecutors in the thousands, so thousands of possible interpretations of these old laws. So when attorneys like me say, well, it depends on how things are interpreted, again, keep in mind you could have 2,000 possible interpretations of all these old laws out there. In Wisconsin, Attorney General Josh Paul said that he will not enforce Wisconsin's 1849 ban. That sounds pretty good. For most employers at least. But again, looking at the local level, on June 29th, the Sheboygan County DA Joel Urmanski said that he will enforce the 1849 law. So as far as we can tell, he's the first person, DA in Wisconsin to say that. And again, that's an example of differing opinions and different enforcement priorities. So Wisconsin, I think there's 72 counties. Sheboygan has said, yep, we're going to prosecute. And, what the other 71 counties, I think it would vary. believe Dane County came out and said, no, we're not going to do that. But others will probably say yes. So again, it's going to be a kind of tough, not even state by state, county by county kind of provision. One thing which we, speaking of at the county level, one thing which we don't have a specific bullet point on, but I wanted to flag it for you. I believe that there are at least 51 cities in the different states which have their own enforcement provisions and own laws. In our chart, we provide a link to a website which tries to track these city by city ones. So in other words, you could have operations in a state which is a pro-choice sort of state. Even there, it could be that they have, even within that state, there could be a particular city or village which makes abortion illegal. So if you have a plant or facility in that city or county or village, you may have issues to deal with there, just at the very, very kind of micro local level. So again, it's a little bit of a challenge here, I think, and that's kind of an understatement. We've had questions from clients, will ERISA just preempt these laws? ERISA does have strong preemption provisions, as you know. ERISA Section 514 says that it will supersede any and all state laws if the laws relate to a plan. Preemption analysis is always tricky. Almost every year, the Supreme Court comes out with a new ERISA preemption case. They've slowed down a little bit. It used to be every year. One year there were like 3 cases or something. It was kind of crazy, but again, they keep flip-flopping a little bit here because it's a tough area of the law. So again, ERISA preemption, always is changing a little bit. With regard to our high-level takeaways, if a state law refers to a plan, requires a plan to provide a particular benefit, or directly impacts plans, directly impacts communications, those are much more likely to be preempted. For example, there's a recent Illinois law which kind of gets into the weeds from an ERISA perspective and plan communication perspective. That one seems, much more likely to be preempted than some of the laws that we'll be talking about here, which are more general criminal provisions. And let's go through a quick example. Texas has a civil penalty which applies to a person who knowingly engages in conduct that aids or abets the performance or inducement of abortion, including paying for or reimbursing the cost of an abortion through insurance or otherwise. So that is geared to the heart of what an ERISA covered health plan does, paying for or reimbursing the cost of an abortion through insurance or otherwise. So that to me is a law that if you are an ERISA covered entity, probably would be preempted, and therefore we could probably ignore that particular Texas civil penalty law. I think it's a strong argument. There is no case law on it yet, though. So again, it's, and there is some risk. You don't want to be the first person who faces a lawsuit in this area. But again, if you are that unlucky person, it seems like you would have a pretty decent argument, I would say, there. All right, what are the limits, though, with respect to ERISA preemption? ERISA generally does not preempt states' criminal laws. And so it's one of those areas where there's sort of a limit here. ERISA, if there's a general criminal law that's out there, ERISA is not going to offer a ton of protection here. If the criminal law is of general applicability. And let's take one which I think is of general applicability most likely. There's an Alabama law. Any person who aids, abets, or prescribes for a non-life of the mother saving abortion shall on conviction be fined not less than $100, no more than $1,000. It may also be imprisoned in the county jail or sentenced to hard labor for the county for not more than 12 months. And so again, that has no reference to an ERISA covered plan. It doesn't talk about a health plan, doesn't talk about activities, doesn't talk about paying for abortions, reimbursing, non-life of the mother saving abortions. So to me, it seems like a general criminal law, one which is unlikely to be preempted by ERISA. Again, if you were faced with that situation, you would try to make the best arguments that you could. You could still try to argue that Federal law in general should preempt state law. So even if ERISA's specific preemption provision in 514 is inapplicable, you try to argue, well, but you have the general principle that federal law should trump it. So anyways, you would have, I think, some pretty some arguments there, but in general, they're not going to be extremely strong arguments. So this particular, Alabama law, and there's several others that have the same kind of provision in it, are risky from an employer sponsor perspective. In contrast, let's suppose that a state passed a law which imposed criminal penalties on specific claims processing activities of a plan, TPA, or PBM. You all may have seen, and if you haven't seen, I can forward on to BHCG, and BHCG can forward it all to you. There's a July, or honestly, you could probably just Google it too. There's a July 7th, 2022 letter from the Texas Freedom Caucus. They have a website. This is available on their website. Group of Texas politicians to Sidley Austin. Sidley is a very large law firm based in Chicago with a Texas office. And they note that there are published reports that Sidley will pay for travel expenses for abortion for their Texas employees. The group believes that this violates Texas law, which imposes a criminal penalty. This is the old 1925 law on anyone who, quote, furnishes the means for procuring an abortion knowing the purpose intended. And so their argument is that, hey, Sidley, if you are agreeing to pay for these travel expenses and you know that they're for an abortion, you are, furnishing the means for procuring an abortion under this 1925 law, and therefore that is a criminal activity. You should really read that letter. It's fascinating. They threaten to basically disbar every single Sidley Austin attorney. They want to, they're kind of reaching out to prosecutors in essence, that prosecutors should try to shut down their whole business in Texas, sort of an open invitation in that area. So very fascinating, very scary. So far, no local prosecutor has actually taken them up on that offer. So again, nobody's followed those breadcrumbs through that we know of and brought an actual criminal complaint against Sidley. But that seems to be the scare tactic, at least that's going on here. The Texas group also claims that the law will extend to drug-induced abortions if any part of the drug regimen is ingested in Texas, even if the drugs were dispensed by an out-of-state provider. So if a pregnant woman takes the M&M type of abortion-inducing drugs, I always garble the name here, mifepristone and misoprostol, I think. During the first 10 weeks of pregnancy, this group argues that a TPA, PBM, and employer would need to know where each drug was ingested in order to determine legality. That is difficult, I think. How would you know, if a woman receives it in New Mexico where there are no limitations like this, drives over to the border in Texas, takes it there. This group at least claims that your role in providing that M&M drug, even though it was in New Mexico, would be problematic because the drug was taken in Texas. I think there's some, obvious defenses you would have. You don't have knowledge of that. You don't have the proper mens rea. The law is too ambiguous. You right to interstate travel. You'd have a whole bunch of things that you would assert if you were the unlucky company who got, sued over this or had a criminal charge brought against you. So again, I think you would have some defenses, but it does raise some issues. And if we start going down the path of, well, how would we minimize this risk? Maybe we start putting language into an SPD that plan enrollee represents and warrants that, any abortion services or drugs that they receive are legal in the area that they are receiving it. Will that really protect us? Hard to know. Again, no case law on this, but it seems like it's probably better than nothing. So, trying to put something in writing where we kind of disclaim it, we try to, remove our fingerprints from this, if you will, try to minimize that is probably a good idea. Another angle on this Texas letter, again, which I think is just fascinating, they state that in the next legislative session, it will introduce into the law to prohibit any employer in Texas from paying for elective abortions or reimbursing abortion-related expenses. So again, they're getting directly to the heart of, can you even help pay for it? And they're basically saying, well, we don't have, a law specific to that right now, but we will in the future introduce that kind of law. And if they keep it as a civil penalty, I think it probably would be something that ERISA would preempt. If they actually drill down and try to make it a criminal penalty, as they threaten to do, and they say that they'll apply it to self-insured plans, I think it's actually kind of odd, because in that situation, if they do that, I think ERISA probably will preempt it. In other words, if they have a criminal law of not general applicability, if they enforce it against specifically self-insured plans, in that case, I think ERISA probably will preempt it. So I think the group actually kind of has it backwards. I mean, don't tell the group that. It would be, we don't really want them knowing that they kind of have it backwards here. But I think that that's probably the analysis. So again, there's some concerns out there. All right. In terms of how to minimize some of these risks and kind of deal with it, one thing that we've talked to clients about, I've explained that I basically view there as being two paths. The first path is relying upon the Pregnancy Discrimination Act. You may not be familiar with the Pregnancy Discrimination Act, but it's a law from the 1970s, which basically says that employers cannot discriminate against pregnant employees. And so that is, probably not objectionable. I think everyone, has complied with this and lived with it, and we don't really even think, two thoughts about it. But interestingly, the PDA has a couple FAQs from 1978 or 1979 that say that health plans have to cover abortions in one situation, which is basically a life of the mother type of situation. You also have to cover complications from abortion. So if your health plan, pays for an abortion, or I'm sorry, if your health plan doesn't pay for, say, what may be called an elective abortion, or an abortion due to rape or incest or genetic abnormality, if you don't cover that type of abortion, and so the person pays out of pocket for it, but then there's a complication, there's something goes wrong, you do have to pay for it under the PDA. So that's basically how that PDA provision works. The thought I guess I have is, would the PDA extend and offer some kind of preemptive effect here? Would this be another argument that employers could use to add to their ERISA preemption argument? So in other words, if Alabama or Texas or some of these other states starts asserting laws and claims against you, would you be able to say, hey, we have this in our back pocket, you can't bring a claim against us, our health plan complies with the PDA, federal law, trumps state law, therefore we don't have to worry about it. Very limited case law on the PDA and preemption, because again, most of these state laws, you never got to the PDA. Roe versus Wade preempted it, Casey preempted it. So we never really had to trot out a PDA defense. So I think that issue will be litigated in the future. And it seems like offhand, it seems like there should be a decent defense there. So if you went down the PDA path, where again, you only covered abortions in one situation, life of the mother or complications, I think that you have a fairly safe, as safe as you can probably be for right now, type of argument against state laws. Problem with that, though, is that many employer-sponsored health plans go beyond that. If you have to use an example from the news from a couple months ago, if you have a 10-year-old girl under your health plan and she gets raped by her uncle, that's a very sympathetic case. And so, your health plan may cover an abortion in that situation right now. If you wanted to stick to the PDA path, you'd have to eliminate coverage for that. You have to say to the 10-year-old, nope, sorry, we used to cover that, a couple months ago, and we eliminated that coverage. Sorry, you're out of luck. And that's not an extremely palatable position for many employers, especially if you already cover it. In other words, cutting back on coverage that you already have could draw attention to it. You'd probably have to notify people through a summary material modifications. You'd have to kind of publicize it a little bit. And many employers are not too keen to publicize a cutback in their abortion coverage. On the other hand, some employers are happy to do it. So again, it does vary, I think, on an employer by employer basis. Again, the PDA we've had some clients say, could we, can we just eliminate coverage of abortion? Because we do have some clients like that. And again, the PDA may limit your choices here. And so you may have to kind of work through that. If you're a religious employer, I think there's some additional religious freedom type arguments you could make. If you're a non-religious employer, maybe it becomes a little bit harder. But again, if you're looking to sort of greatly restrict coverage, the hurdle you have here is really the PDA, and you'd want to work through those issues. We did see an interesting survey that came out about a month ago. What changes are employers considering to abortion coverage from the International Foundation of Employee Benefit Plans? And the foundation did, again, kind of a quick survey of its members. And about half of them said no changes to current coverage levels. So kind of a status quo. Let's just wait and see. We don't want to expand coverage. We don't want to limit coverage. Others were, more explicit of, hey, we don't have any idea. We're gonna, we haven't even figured out if we're going to keep the current coverage. So again, about 26% there. 26% were exploring expansion of coverage. In my experience, the bigger employers felt more pressure to kind of expand coverage. The 200 employee companies, privately held, not well known from a public perspective. I don't think they felt that pressure to come out publicly and with an expansion, while the bigger companies did, just to be blunt. So again, it really kind of varies by company and the industry you're in and the pressures that you face, your need to compete for talent and everything else. So again, really a variance here. 2% unable to change through laws. Again, that may be a PDA reference. Totally eliminating abortion coverage, less than 1%, and that's pretty consistent with what we've been seeing here also. Again, that is not on the table for most clients, the vast majority of clients, but who knows, it could change in the future too. All right, so preemption wrap up. Unfortunately, employers, TPAs, and PBMs now need to consider hundreds of possibly applicable state laws, that may even be thousands, to be honest. Ignoring them seems risky, but I know that some clients will do that and take a wait and see approach. Talk to some clients and they said, we don't want to get into it. We don't want to deal with it. So again, that's not our preferred approach. We recommend that clients be a little bit more proactive than that. But I know that some companies will just say, nope, we're not going to deal with it. So it is what it is. Preemption analysis, again, I think once you've kind of gone through these laws, and again, that gets to that chart that Jeff mentioned where we cover, dozens of these different state laws which are out there. That's kind of the key, is trying to figure out, okay, what state laws are out there, what applies, will this one be preempted by ERISA? How can we minimize the risk? That's kind of your to-do here, if you will, to walk through and verify what laws apply to you and how do you, monitor for changes in the laws here also. All right, I'm just checking for questions. Pause here. It looks like there are no questions that I see. Jeff, are you seeing any questions? If not,
John, there aren't any yet. And what I think we should do is to wait until the end for you to take questions. But once again, for any of you that do have questions, just enter them into the Q&A section on your screen. Thank you.
Sounds good. All right. Helpful reminder. Again, we'd love to see your questions or thoughts here in this area for sure. Telemedicine and mail order, you may have read that some states view telemedicine as a gap in their abortion restrictions and are eager to eliminate that gap to prevent mail order abortion drugs from being sent through the mail or courier to plan enrollees in particular states. There is an argument that the FDA, which has approved these abortion-inducing drugs, that the FDA rules would actually preempt in that situation. Therefore, we would not have to worry about those particular state laws. So that's an additional preemption argument, which is currently actually being sort of litigated at the federal level right now. Let's hope from an employer perspective that we don't have to deal with it, because you could just come up with crazy law school exam type of questions where it's very difficult for a state or an employer to monitor this. For example, suppose that Tess is in Texas and Cindy's in California, both are pregnant and are friends, both conduct a telemedicine call with a doctor about obtaining an abortion. Texas wants to bring an action against Tess for doing that. Will Texas know where that telemedicine visit took place? Will the employer TPA be able to flag it as an illegal abortion and thereby deny the claim? What if Tess flies to California to visit Cindy and Tess takes the call in California? Micro managing details like that. How is it ever possible for an employer or TPA to even figure this out? And again, it may require TPAs and PBMs to dig into this a little bit more. I work with a PBM. They are thinking of every time they get in an abortion-inducing drug request, sending it through a separate prior authorization provision where they basically try to say, okay, let's slow the process down. Let's take a look at it. Where is the person living? Where are they going to be shipping the drugs to? Kind of human involvement, which is very abnormal in the prescription drug context. In that context, you go to CVS or Walgreens or wherever your pharmacist is, you present your card, 4 seconds later it gets approved and you walk out. And now maybe we can't have 4-second approvals. Maybe we need to slow down the process. Maybe we need to, figure it out. And again, if you are the employer and if you want your TPA or PBM to kind of slow that process down, I think you have to talk to them about it. You have to explain, here's our concerns. What are you guys doing? How can you help? And then getting it in a contract, right? Making sure that they agree to follow what they verbally tell you they will do. So again, there's some to-do work here for employers. I do think you have to talk to your vendors about, how are they approaching this type of issue? In addition, some states have specific laws prohibiting the shipment of abortion-inducing drugs through the mail, courier, or delivery. I think we identified 8 or 9 of them in the chart. One of them is Arkansas. Arkansas says it is unlawful for any person to provide any abortion-inducing drug via courier, delivery, or mail service. Criminal penalties for violation, no specific ERISA plan references, so ERISA preemption is unlikely. So again, it's just a flat out prohibition. You can't send those abortion-inducing drugs via courier, delivery, or mail service. Would you have some PDA preemption arguments? Maybe if it was really to, save the life of the mother, but if it was really to save the life of the mother, wouldn't they probably be in the emergency room? Probably wouldn't be doing it through the M&M drug combination. So again, it raises some tricky issues. Our thought is that employers should identify these laws, talk to your PBM to see if they can change their procedures, maybe on a state-by-state basis, where, again, if there's 8 or 9 states out there which have this kind of prohibition, your PBM would flag that and say, okay, even though the company is based in, Wisconsin, let's say, you have a 20-year-old woman who's a college student at the University of Arkansas, and, she requests the drug to be sent down there. We would maybe say, no, you can't have the drug be sent down there. Maybe you have to go to your local pharmacist or doctor to fill it. We don't want our fingerprints on that. Now that would be interesting from a HR or benefits communication perspective, because you'd end up in a situation where your benefits would vary by state. And I don't think we've ever had to do that in the health plan context. In the past 50 years, I'm not aware of companies saying, if you live in this state, you get this benefit. If you live in that state, you do not get that benefit. That would be, a difficult communication piece with the people in Alabama or Arkansas or wherever, say, hey, you're picking on us. Why are you doing this? Why are we treating like second-class employees? You can just see the communication issues that could result if they feel like they're being kind of treated worse than like Wisconsin employees, let's say. So again, it's a tough one. Maybe it's easier to just eliminate that for all 50 states. So rather than deal with it on a state-by-state basis, maybe we just say, nope, nobody gets it at all. Again, that would make some sense to me also too. So again, some different plan design issues that kind of tie into the legal approach here. Another big unresolved question is whether a state can enforce its rules when a resident's conduct takes place in another state. So let's suppose that Joan, a hypothetical employee, plan enrollee, travels from Missouri, where abortion is very restricted, to Illinois, where it's not very restricted. Can Missouri punish Joan when she returns from the procedure? At least one Missouri lawmaker introduced a bill earlier, I think it was actually December 2021, to punish Missouri residents in this situation. The bill did not become law then. It does raise difficult questions that we have not really had to deal with a lot in this area. For example, there's an interpretation that the US Constitution gives citizens the right to travel. So if you want to hop in your car and drive to another state, you have the right to travel under the US Constitution. Problem, though, is that that is an unenumerated right. In other words, if you search the Constitution for right to travel, you don't see it in there. Unenumerated rights are less on solid ground, kind of like the right to an abortion, right? That's not specifically noted in the Constitution, and now that right is gone. So the right to travel rights, again, in theory, maybe could be restricted. Maybe the Supreme Court would come out and say, no, you don't have a right to travel if the reason why you're doing that is because you're engaging in an activity which would be illegal in your home state. Maybe that'll be an exception to the right to travel. That seems pretty doubtful, though. Justice Kavanaugh, in a concurring opinion to the Dobbs opinion, which reversed Roe, said that this right would be protected. Would the other 4 justices agree? I think probably. So I think you probably have 5 of the 9 justices, maybe more, would agree that there is a right to travel to another state to obtain an abortion, and therefore, again, bringing it back to the employer, level, therefore, if you pay for that abortion in Illinois for the Missouri resident, the argument would be that that payment should not be viewed as illegal. Your health plan should be able to pay for it. Would again be the argument. Could a state go beyond that, though, and say, well, okay, we can't prohibit travel, but we can still punish the woman upon return. We can penalize the TPA or employer for paying for it. Maybe. Again, we just don't have cases out there. There was an interesting case that I found, I think it was 1941 U.S. Supreme Court, involved a sponge diver in Florida. Florida prohibited the use of scuba gear to collect sponges. I think it was an effort to make it harder to collect sponges, to protect sponges in the Florida coastal waters. And there was a gentleman who was off the waters of Florida in international waters who used scuba gear to collect the sponges. He dove down and collected the sponges, brought them back up. Florida charged him with, I think it was a criminal charge, for the use of scuba gear, even though the use of the scuba gear did not occur in Florida waters. Interestingly, and I think somewhat amazingly, the Supreme Court said, yes, Florida can prohibit those activities which take place outside of Florida if they involve a Florida resident. So again, maybe this right to travel is not as broad as we think it is. Maybe there is some additional concern here. So again, to be determined, but another kind of sticky point from an employer perspective. Despite some of those risks, many employers are considering whether to implement travel benefits and, again, paying for a pregnant woman in, say, Oklahoma to travel to New Mexico for an abortion. What should we be thinking about if we're an employer who's interested in doing that? The Internal Revenue Code does offer some tax-free benefits for medical travel, but probably will not fully shield all expenses. In other words, you may end up with a situation where some of the cost of that travel may be taxable. Now, don't confuse taxability versus illegality. Just because it's taxable does not mean that it's illegal. So again, you should not be too worried about that if you're an employer. It just means you might have to pay more taxes. A woman staying in a medical facility probably will be non-taxable. The meals at the medical facility should be non-taxable. Transportation primarily for and essential to the medical care should be non-taxable. We've had questions about, well, is there a geographic limit on that? For example, would a flight to Hawaii, I want to fly to Hawaii for my abortion. Would that really be primarily for and essential to medical care? Couldn't you fly to, Illinois or New Mexico or something like that? So couldn't you drive there? Is there some baked in provision saying that, hey, a flight to Hawaii, maybe you're really going for recreation or something like that. So some employers have talked about trying to put a 100-mile, 200-mile kind of limit on it, and to me that makes a lot of sense. It makes it harder for the IRS to argue that it should be taxable. Meal expenses while traveling, probably taxable. Hotel expenses while traveling, code usually limits the cost to $50. Could be $100 if there's a necessary companion. Mileage rates, you're probably familiar with the IRS mileage rates. Normally they're, I forget what it is now, like 60 cents a mile or something. For medical expenses, it's a strangely low 22 cents per mile. So again, you have to kind of look at that and make sure that your payroll system is picking it up. What about designing this as kind of a lifestyle fund up to $4,000 could be used on various lifestyle activities, whether it's flying yourself to a beach to do yoga, while you watch the waves crash, or to have an abortion, or to do something else, peace of mind type of activities. That it's an interesting idea. Probably will all be taxable. Again, taxable doesn't mean that's illegal. I think it may help too from some of the aiding and abetting provisions. If you think back to that, that Alabama law we talked about at the beginning, that may be helpful because maybe we can argue, hey, we didn't know that we were paying for an abortion. We don't have the right mens rea, the right state of mind, and therefore, we shouldn't be charged. There does raise questions though, will somebody have to actually administer this hypothetical $4,000 lifestyle fund? And if they administer it, will they be taking notes that, hey, so-and-so flew to this place to get an abortion. They drove to this place to get an abortion while somebody else flew to Florida to go to the beach and do yoga there. In other words, if you have that paper trail, does it become problematic from a state law of aiding and abetting criminal law perspective? So again, to be determined, but in general, when I talk to clients, I've said, it's probably better to, reduce your fingerprints, if you will, here, trying to minimize the amount of touches you have is in general, probably a good idea. Another kind of obscure provision that many clients don't appreciate or know about is that under the Internal Revenue Code, the code says that a health plan cannot provide tax-free benefits for illegal operations or treatments. So if something is simply illegal, you can't cover it. This doesn't come up very often. Came up in the past with like medical marijuana, which has been prohibited at the federal level. Can a health plan cover that? And so you run into this illegal operations or treatments type of issue, or importation of prescription drugs from Canada is another example where it's come up. And again, if you're importing those drugs on an illegal basis, that means that it'll be taxable. So you kind of run smack dab into the taxation problem. You also have the basic problem that it may be just illegal, but again, there's the taxation problem too. Could your TPA or you just assume that abortion-related expenses are not illegal? For example, there was an op-ed, I think in the Washington Post, from an Ohio doctor who said, if I had a 10-year-old rape victim come into my office, even if I can't perform that in Ohio because they're past the applicable time period, I would just do it. I would just come out and do the abortion on the 10-year-old rape victim. And if they prosecute me, they prosecute me. If they try to put me in jail, I'll take an act of civil disobedience and I'll run the risk. That's interesting, but from the employer plan perspective, what if they send you a bill for it? Do you pay for it? And if you pay for it, are you kind of aiding and abetting? Are you an accomplice in the illegal activity, if you will? And that's a tough question. I kind of suspect that a doctor who is kind of knowingly violating the law, I suspect that they probably won't bill for that abortion, but I think they could. And so again, should you be talking to your TPAs if you're an employer and saying, okay, what process do you have in place to monitor this? How do we make sure that we don't accidentally cover an illegal abortion because some doctor somewhere wants to engage in civil disobedience, if you will? So again, tough one. I think it's worth talking to your TPAs about that. Um, in terms of determining illegality, will you even have enough information to determine illegality? That Texas letter where the politicians argue that, hey, if the drug is dispensed in New Mexico where it's fine, but then it's partially taken in Texas where it would be illegal, that just seems very difficult. I mean, I want to say bonkers, but maybe that's not the best, legal term to use, but, very, very difficult. Hard for me to believe that it'll really come to that. It just seems so remote. But again, they're threatening it. They're saying it's possible. I do think that letter's a little bit of a scare tactic, but on the other hand, it may be effective too. So it's kind of a tough one. In what state is illegality determined? For example, suppose an abortion for a woman is illegal in Wisconsin, but legal in Illinois. The woman drives from Wisconsin to Illinois and obtains the abortion. Is the legal illegal status based on where the woman lives, where the employer is based, where the plan is based? Probably determined based on where the service is received. There is some IRS kind of older guidance out there, which seems to indicate that that would be the answer. But again, not a lot of guidance, and it wasn't in the abortion context. And, could I see the IRS under Joe Biden reversing that position? Probably not. Could I see the IRS under a different administration reversing that position? Yeah, I could see that happening, saying, no. If it's illegal anywhere where you have connection, that becomes taxable. So again, hard one to deal with. It's also unclear if when the IRS talks about it being illegal under the Internal Revenue Code for tax purposes, if the only penalty is civil, not criminal, does that really make it illegal or not? And again, no clear, good guidance on that one. Could a state provide that its tax code does not mirror the federal tax code? The idea is that a state does not want to subsidize the costs or tax deductions of abortion-related expenses. We think the answer is almost certainly yes. And many states take positions that are different than the federal tax code. For example, like New Jersey still does not believe in health savings accounts, HSAs. They've been around for almost 20 years. And New Jersey's position is we don't care that the federal government gives these fantastic tax benefits for HSAs. We in New Jersey aren't going to do that. And so they don't do it. So again, the taxation varies. In doing our research, we found one state, Kansas, which specifically makes abortion-related health benefits taxable at the state level. It seems like they did that back in 2013. Maybe you all knew about that, but that was not something I had focused on before. And so it seems that, like, if you have a health FSA, HRA health plan that treats abortion-related reimbursements or coverages, for people in Kansas, it seems like you actually should have been taxing those benefits since about 2013. And if you haven't in the past, again, I think you should probably look at trying to do it on a going forward basis. One fear I have is I don't quite know how much broader it is than Kansas. I could see states having a general provision in their tax code that if some kind of service is illegal, then we're not going to subsidize it. And so, in other words, they may not call out abortion specifically, but they may just have a more general provision in their tax code saying, as a catch-all, and if the service is illegal, then it becomes taxable. So I do worry that there is some risk from a state tax perspective, which is out there, beyond Kansas. All right, if the benefit is taxable, can the TPA track this? Will the TPA report that to the employer? We've had questions about, can the employer even get this information? If we know that Sally Jones had a, $2,000 abortion expense, what type of HIPAA issues does that concern raise? What about medical privacy concerns? So again, I think those are all things to work through. In general, HIPAA does say that you can receive information to administer the plan. So I think there's probably a decent HIPAA argument that it's okay. You may not want that information, so it may raise some, broader issues of, hey, can we just not get this information? But in general, I think that there is that concern. Will the employer or the TPA or PBM handle tax reporting and withholding? I've not seen any TPAs or PBMs raising their hands and saying, yeah, we'll handle tax reporting and the withholding. I don't know how they do that exactly. They don't have control over the paychecks or anything like that. So again, this may bounce back to you as an employer to deal with. If you are providing travel benefits, what vehicle should you use to provide the travel benefit? Existing health plan seems like a good vehicle here, probably good from an administrative perspective. Rather than creating a whole new health plan just to provide this particular travel benefit, baking into the existing health plans, you don't need a separate SPD, you don't need a separate 5500 filing, things like that. That's probably pretty good. If you are worried about covering all of your employees, maybe more challenging. Most employer-sponsored plans, they cover maybe 70% or 80% or 60% or so of their employees, but then there's always a gap. You always have 10, 20, 30% who are not covered by the health plan. Does the employer want to help that certain percentage? If the answer is no, we don't care, then that's, again, easy. If the answer is yes, we want to cover them, that becomes harder, because then we need a separate plan, a separate vehicle to address that group of people. Could it be through an EAP, an employee assistance program? Generally cannot provide significant medical benefits. Would this be significant? I'm not quite sure. I mean, it kind of depends, I think, upon, the cost of the abortion, the cost of the expenses. When you think about some of the EAP benefits you provide right now, a counseling service, a person talks to a counselor for, 3 to 5 times, 5 to 7 times, something like that. Could be a lot less in value compared to an actual medical procedure where the person has to check into a clinic. Could be, maybe a couple $1,000s or so worth of expenses, which it seems more significant than a typical EAP benefit. But again, it's not quite clear how the federal agencies would treat that. Other types of plans, separate medical plans. There's a HRA called an EBRA, which is out there. Again, I mentioned that kind of lifestyle plan. Again, those are all things to kind of think through on the travel expense side. Another state law issue we wanted to flag is advertising for abortion services. And there are a lot of states out there, a number of states, which used to prohibit the advertising of abortions. I think there's probably, I forget what the number is in the chart, like 9 or so, that they would say things like, it is illegal to advertise or provide other notice of the availability of an abortion. So they didn't want doctors advertising abortions on big billboards. And that makes sense. And I'm not too worried about doctor advertising because I'm worried about employers here. And but when they go beyond it, beyond the simple advertisement type of language, it does worry me. I know that Louisiana has a somewhat broad definition of what an advertisement is. Arizona is one I repeated in here. A person who willfully writes, composes, or publishes a notice or advertisement. Again, a notice, could our summary plan description be a notice of any medicine or means for procuring or facilitating a miscarriage or abortion is guilty of a misdemeanor? I can see an argument that, when you publish your SPD or publish your plan document, that is a notice of the availability of an abortion service. And therefore, just putting out an SPD, could violate this state law. And again, you probably have some preemption arguments there. You can say, hey, federal law requires that we do this. So tough luck, Arizona. But again, it raises that issue, and it kind of forces us to think through, okay, what can we do here? How can we kind of minimize that risk? If we put some language into the SPD saying, hey, we're not trying to encourage it, don't view this as an advertisement. In other words, go through each of these states and kind of use the language that they use to kind of throw it back at them saying, no, we're not doing that here. We're not trying to induce it. We're not trying to encourage it, things like that. Interestingly, we haven't talked about contraceptives, but if you look in the Arizona law, it says for abortions or for the prevention of conception. So actually, when we talk about if you have a non-grandfathered health plan under the ACA, you have to provide coverage for contraceptives. You have to describe that coverage. Again, even just a notice of that description raises an argument that you're violating Arizona law. And again, difficult. I think you'd have some arguments, but we're really seeing a true conflict here between federal and state law. Other considerations, I've heard some folks say, well, what if we paid benefits through a VEBA trust? Would that help out with the criminal law aiding and abetting issues? Maybe make the employer one step removed, remove the employer's fingerprints from it. But then that just raises the question of, well, who established the VEBA? Who directed the VEBA? Who controls the VEBA? So, you can just see the state saying, okay, yeah, maybe it's not the employer, maybe a VEBA is a separate legal entity, but somebody controls that separate legal entity. We're going to go after that person or group of people, a benefits committee, something like that. Will some TPAs and PBMs simply refuse to process these claims? Will those claims maybe be offloaded to a TPA or PBM in a pro-choice state? I could see that happening from an industry perspective in the marketplace. I could see somebody in Oregon saying, hey, we are the abortion claim processing TPA. And so if UHC or Anthem or Cigna won't process that claim, they can send it to us and we'll process that claim. We're never going to open up an operation in any other state. We're in Oregon, which is probably the most liberal here, from a pro-choice perspective. I could see it. Now, I don't think it has happened, but I could see that happening. TPAs and PBMs are probably afraid of losing business, so they've been reluctant to say a lot from what I've seen. I've seen just general statements from them saying, we intend to comply with all applicable law, but what does that mean? How do you do it? How do they answer some of the questions we raised here today? Those are kind of the tougher questions. A couple other considerations: high deductible health plan issues if you offer the abortion or travel benefits on a pre-deductible basis. So again, if you have an HDHP and if you want to offer these abortion travel benefits on a pre-deductible basis, you are going to have problems. You have to do it on a post-deductible basis. Mental health parity, we've gotten questions about whether or not travel benefit here on the medical side will raise concerns because you're not providing similar travel benefit on the mental health or substance use disorder side. Possible, there is some possible risk there. I'm not too worried about it, especially if you do have kind of a general provision in your plan saying, hey, we'll cover any kind of necessary travel benefit where we simply have to do it because of state law restrictions. So if you put in something like that, I think that definitely cuts down on the risk. I can't guarantee it eliminates it, but to me it seems logical. So if, for example, Texas in the future bans the provision of mental health services, if you're willing to step up and say, well, sorry, we're going to pay for our employees to go to another state to get those mental health services. Sorry, Texas banned it. I mean, to me, that's a pretty strong argument that you're not favoring medical surgical. You just have a more general provision that you will pay for travel expenses when a particular medical procedure is banned at the state level. Don't forget about the smaller plans. Even if your plan is pretty tight, your medical plan is restrictive on the abortion coverage. So you take a PDA approach, you only cover life of the mother exceptions. Your health FSA or HRA may be way broader than that. And so your health FSA or HRA may raise these same concerns, and you may have to deal with the same issues here. So again, don't forget about that kind of issue. HSAs, if you offer guidance to plan enrollees, consider what to say here. You don't have to offer any guidance, but again, if you have somebody in, say, Kansas, you may want to say, hey, you should go and look at the Kansas tax issues there. All right, well, that was a lot. Jeff, how are the questions looking? Jeff, I hear some background noise or music. I don't know if there's any way to shut that. Well, I do see some questions here, so let me kind of go through them. The first one is, to what extent may an employer ask for PHI details to validate the travel was for medical procedure versus recreation vacation? Great question. We did, I think I did touch on it after the question was asked. And in general, HIPAA says that if an employer or plan sponsor needs to obtain any information, including individually identifiable health information to administer the plan, the employer can get it. You'd have to make sure that you're complying with the firewall requirements. So it can't be just everybody within the employer who gets access to it. It's supposed to be a limited group of people who can obtain access to it. So, so again, that is possible in that scenario for you to get access to those PHI details if you need it. And then Jeff, I don't know if you're on, I can go to the second question.
Yeah, John, just go through all three. So the second question is, will the presentation be circulated? And the answer is yes. And this is being recorded, so there will be a recording that's going to be available. And then we'll also do an executive summary that we will share.
Yeah, sounds good. And then the last question, are the criminal laws actually requiring a level of knowledge or intent or strict liability like statutory rape? That's a great question. I think it does vary by law here, and it may be subject to some court interpretations. And again, we don't necessarily have recent cases here. There are old cases interpreting some of these old laws, and some of them are just absolutely fascinating to read. For example, one of them in the aiding and abetting context, I forget what state it was, but I mentioned it in the chart, involved, I think, an 18 or 19-year-old pregnant woman who went to her doctor. This is like 1925 or 28 or something like that. And or maybe it's in the 30s, I don't remember, long time ago. And she asked the doctor to do an abortion. He said, I don't do abortions, but I know how to help you. Go to this street corner at 7 p.m. and you'll see a man driving a pink Cadillac. Get into the back seat of the pink Cadillac. He'll take you to a spot where the abortion can be done. In that situation, I believe, unfortunately, the abortion went wrong. I think the woman died. And then there were criminal charges. And the doctor who assisted, who said, hey, go to this street corner at 7 p.m., got charged from a criminal perspective and was found guilty. So with that aiding and abetting. And again, that, there clearly was, I think, kind of a specific knowledge or intent. It does, I think, perhaps vary. That case was one of those that stood out to me as a concern from the employer perspective, because, is that all that different than one of your plan enrollees calling your TPA and saying, hey, where can I get an abortion? And the TPA says, oh, well, here's a list of providers, and here's how you go, and here's how much it's going to cost, and here's an advanced EOB saying what the cost will be. I mean, so, again, the question is a great question. I think it will vary by state, unfortunately.
John, Dave Ostendorf has a question.
Hey, John.
Dave.
The whole conversation about covering legal versus illegal expenses, it raised an issue of can we find a way to turn that around and say to the healthcare providers that if they are seeking reimbursement for a service they provided, they are certifying that they believe that service is a legal service, and so essentially pushing the burden of legality over to them.
Yeah, I mean, I think it's a great question. Most of the time, we don't necessarily have a direct contract. The employers don't have direct contracts with the providers, right? So I don't know how we kind of get it into the contract. For in-network providers, there is a contract. So your TPA would typically have a contract with the provider. That may be covered in there, or may not be covered right now. Probably no one really had to think about this in the past. So maybe a good addition that your TPA could include in the next renewal of its in-network provider contract. A tougher problem would probably be the out-of-network provider, where again, we don't have a contract even indirectly with them. So it's a good question. I don't know how we could make them do it, but maybe we could try. And at this point, I think trying is half the battle. So I do like the question. I do think it's a good thought. I think it could be explored a little bit more.
John, could you go into a little bit more detail on the chart and what you have incorporated into the chart?
Yeah, for sure. So what I did was I went through, it ended up being thousands of references to abortion in all 50 states. And I tried to identify the state laws that I thought could impact employers, TPAs, and PBMs, employers with self-funded plans. So it does not talk about provider restrictions. There's lots of restrictions on providers doing partial birth abortions and things like that. You won't see the word partial birth in this chart because I don't really care. That's a provider restriction, not an employer restriction. And so I went through, all these different laws, and in some states there's no issues really. Oregon, I think New Jersey was fine. So there are some, states where really I don't think you need to vary anything at all. But then there's other states where we identify these kind of broad categories. Shipment of abortion-inducing drugs, we kind of break that out and say, here's the 7 or 8 states you have to worry about. Aiding and abetting, here's the 5 or 6 states you have to worry about. Abortion advertising, here's the states you have to worry about. To, again, hopefully give employers kind of a heads up about, okay, here's where we should be focusing our energy and attention. Here's where we should be, kind of monitoring what's going on. So I think it's very helpful. I try to think of it as, if I'm a reader, what would I be interested in? I tried to put different levels of risk into different colors. So yellow is the most risky, green is less risky, no color is below that. So tried to kind of walk through it from an employer, TPA, or PBM perspective.
Okay, and if any of you have an interest in obtaining this chart, you can reach out to me. And for BHCG member employers, John has,
Sure.
because of the relationship that John has, or the partnership that John has in place with BHCG, what we are going to do is to offer this to those that are interested in obtaining it at a lower price point than what John is typically offering for anyone that would be approaching John on a direct basis.
Absolutely. I was gonna say, yeah, normally for other kind of employers, we've typically been charging $7,000. For the BHCG folks who are clients or become clients, it'd be half off, so $3,500 is what we've talked about here.
Okay, thank you, John. And if there are additional questions that you think of after the symposium has ended today, feel free to email those to either myself or Jennifer Lemire. And we will then present those to John and incorporate his answer into the executive summary that we are going to be providing for the symposium this morning. We do have another or 2 additional symposiums that are going to be coming up on September 21st and 22nd. The presenters for both of those are Darren Fogarty and James Gelfand, and we're going to be addressing the Consolidated Appropriations Act as it pertains to broker consultant compensation. So look for those invitations to be coming out at the end of this week. And with that, what I would like to do is to thank again all of you who have joined us this morning for this symposium. And I know that I have found this to be incredibly interesting, and also a bit, from my standpoint, I'm glad that I'm not on the front lines in dealing with this, because there are so many different issues that need to be addressed. And I think John has done a wonderful job in laying those issues out this morning, and also providing a basis for conversations with your legal representatives. And obviously, John is available if you would like to continue, or if you would like to have a conversation with John on these issues. And lastly, I would like to thank John once again for John taking time out of his incredibly busy day to spend it with us, not only in the presentation this morning, but also in developing the PowerPoint. So with that, thank you, and look forward to additional symposiums in the future with all of you. Thank you.